Thank you for joining me for the webinar that we will be presenting today. My name is Jessica Marks with Wolfdorf Rosenthal, and as you can see on your screen there, we're going to be talking about immigrant visa options for scientists and researchers. We're going to be discussing 3 different options. The first 2 are self-sponsored, and then the last is employer-sponsored. The first that we'll be discussing is an EB-11 petition for foreign nationals of extraordinary ability. The second is an EB-2 national interest waiver. And the third is an EB-12 petition for outstanding researchers and professors. If at any time you have a question, please feel free to type it into your screen there. We will have about 15 minutes at the end for Q&A. So let's jump right in here and talk about our first option, which, as I said, is the EB-11. And those letters and number combinations stands for employment-based first preference, first category. Foreign nationals of extraordinary ability classification is reserved for recipients of a one-time achievement, and that is defined as a major international award. So for any of you out there who already have your Nobel or Pulitzer, congratulations, you are an EB-11. For the rest of you, you're going to have to satisfy at least 3 out of 10 criteria, which when taken together, evidence that you have risen to the very top of your field. So from that very language of the regulations, it should be apparent that how you define your field is very important, and it needs to be done at the outset of your case, because the larger the field, the more difficult it is going to be that you've risen to the very top of it. So instead of medicine, you're going to say psychiatry. And then even further, instead of psychiatry, you may say schizophrenia research. So you want to narrow your field so that it is, in a sense, easier for you to have risen to the top of it. I mentioned at the beginning that this is a self-sponsored green card option, but it can also be filed by an employer. It does not have to be self-sponsored. So there are some who say that having an employer file it on your behalf gives you a bit of an edge. I don't necessarily agree with that, but it at least does show that you already have an offer of employment in your field. So if you have an employer, you're currently working in the U.S., or an employer who wants to bring you in from abroad and who's willing to file this petition on your behalf, and you foresee staying with that company for an indefinite period of time, then it certainly doesn't hurt your application. But if you don't and you plan to self-petition, that doesn't necessarily place you at a disadvantage. Some of you out there may have heard of an O1, which is actually the non-immigrant equivalent of the EB-11. The EB-11 is a type of immigrant visa petition, and I'll go into what that is a little bit later. But if you're already on an O1, then you should have a nice package already put together if you're planning on filing for the EB-11. And even though for scientists, the regulatory criteria are nearly identical, in practice, U.S. Citizenship and Immigration Services, which is the government agency that adjudicates these petitions, applies a much higher standard to the EB-11. So don't think that just because you have the O1, that necessarily means that the EB-11 is going to be a slam dunk. So I mentioned that if you don't have that Pulitzer or Nobel, you're going to have to go for a 3 out of 10 formula. And these 10 criteria are on your screen, the first 5, and in the regulations. And this is essentially a checklist for you that you need to review in advance of even deciding whether you're going to pursue this particular immigration benefit. And what I want to address at the outset with these criteria, not to scare anyone, is that they're actually much more complex than you would necessarily realize at first glance. And each criterion actually has some criteria within the criteria. So let's look at that first one as an example. Lesser nationally or internationally recognized prizes or awards for excellence in the field. That actually is 3 criteria within a criterion. The prize or award must be nationally or internationally recognized. Now, what does that mean? Well, of course, right off the bat, it certainly means that no local or regional awards are going to do the trick. They have to be national or international. And then they also have to be recognized. Now, that means that they have to be prizes or awards that are of a sufficient level of prestige or competitiveness to indicate that you have, in fact, risen to the top of your field. And then what do those prizes and awards have to be recognizing in the grant of the award? They have to be for excellence in the field. So if you're trying to establish that you've risen to the top of the field of nanoparticle research, that prize or award in undergrad that you received for being the best physics student is definitely not going to do the trick. It's not necessarily even in the same field, and it's not going to be a lesser nationally or internationally recognized prize or award. I'm going to talk a little bit about student prizes and awards later, but I wanted to just use that as an example at this point as an illustration. Moving on to the next criterion, membership in associations that require outstanding achievements as judged by recognized experts in the field. Again, that's a criterion with several sub-criteria. Any membership that you just get by virtue of paying dues or, being in a certain profession, like a bar license or a medical license, is not necessarily one that requires outstanding achievement. So if it's just a basic level of membership, that's generally not going to do the trick. It needs to be membership that is reserved for those who are outstanding. And then you also have to look at who is determining who is granted membership and who is not. You have to demonstrate that that judgment is being made by recognized experts in your field as it is defined in the petition. The next criterion, published material about the applicant in professional or major trade publications or other major media about his or her work in the field. This is one criterion that immigration is particularly persnickety about, and it's really that language about the applicant that can be particularly challenging for scientists and researchers, because there's oftentimes media reports that are really press releases, in another form, and the research is detailed. The experiment itself, what it revealed, where it was published, when it was published, but even though you may be the first author even, the publication is not necessarily going to mention you by name because the focus is the research, not necessarily who is performing it. So that is one criterion that immigration likes to be very stingy with and say, if I don't see your name in it, then I'm not going to give you this criterion. That's not to say that we don't necessarily find ways to overcome that argument that immigration presents, but if you're going to try and submit evidence that you established this criterion, just be prepared that that's one battle that you may have to fight. The next criterion is participation as a judge of the work of others in the same or an allied field. This is actually one of the easiest criteria for a researcher and scientist to satisfy, because if you're in academia, then odds are you've probably done at least some peer review work. Now, that being said, some of you may only be doing peer review work that is forwarded to you by your PI or your advisor. And I strongly recommend that if this is a petition that you are considering pursuing, that you start asking for the review request to be sent to you directly, because that's obviously going to be much more persuasive evidence that you have been recognized in the field as opposed to just your PI or your advisor asking you for a favor. So the last criterion on your screen there is original scientific contributions of major significance to the field. So that's another one of those loaded criteria. It has to be an original contribution. It can't just be duplicating the work of others or even work of yourself, unless that initial work was original. And then it has to be of major significance. It has to have had some impact on the field. It can't just be an original experiment in and of itself. It has to be a contribution of major significance to your field as a whole. Now you should see the next 5 criteria on your screen. And just like with the peer review, the authorship of scholarly articles in the field should be a criterion that is pretty easy for most of the scientists and researchers on this call to meet. You should have at least one publication if you are going to be pursuing this EB11, and obviously more than one would be very beneficial, because if you are in academia or even in private industry, if you're a scientist and researcher, the immigration examiner who's reviewing your petition is going to expect you to publish, because they know that in academia especially it's publish or perish. So if you don't have a pretty hefty list of publications to your credit, then that immediately places you at a bit of a disadvantage. The next criterion is display of the applicant's work in the field at artistic exhibitions or showcases, performance in a leading or critical role for organizations or establishments with distinguished reputations. Notice all the criteria within that criterion: leading or critical, distinguished reputation. Commanding a high salary or other significantly high remuneration for services in relation to others in the field, and evidence of commercial success in the performing arts. Now, one thing I want to mention, because you'll notice that on that page alone, there were 2 criteria that were specifically reserved for artists, artistic showcases, and success in the performing arts. The regulations specifically provide for a bit of creativity and flexibility, and they say that when the criteria, those 10 criteria I just discussed, do not readily apply to the occupation, comparable evidence of extraordinary ability may be submitted to establish. So because there's those 2 criteria that are specifically reserved for the arts, I make a point of always arguing comparable evidence for scientists. So because scientists can't argue that they satisfy the criterion relating to displaying their work in artistic showcases, you can submit comparable evidence that you have presented your work in national or international conferences in your field. And obviously, the more selective and prestigious those conferences are, the more compelling that evidence is going to be. Along those same lines, invited and oral presentations are going to be more persuasive evidence than simply having a poster. So that only addresses what is the first step in the EB11 analysis. That's the criteria. Do I meet at least 3 out of 10 if I don't have that major international award? So assuming the answer to that is yes, and you get to pass, go and collect your $200, that unfortunately is not a win. There's still one more step in the analysis, and this is where it gets very challenging, and it's so difficult to predict the outcome in these cases, because the second step, which is called the final merits determination, is incredibly subjective. This is basically the stage at which the immigration examiner sits down, looks at all of the evidence that has been presented, and says, do I actually feel that this person is extraordinary? When I look at the evidence in its entirety, does this paint a picture to me that this person has enjoyed either sustained national or international acclaim and recognition for his or her achievements? Because the 3 out of 10 criteria is not it. The overarching standard for EB11 classification is whether the person has enjoyed sustained national or international acclaim and recognition for achievements in the field. So if the evidence does not satisfy that standard, the case can still be denied even when you have evidence of satisfying at least 3 out of the 10 criteria. So the example I give there is reviewing one manuscript, authoring one article that's published, and receiving one lesser-known award over the course of your entire career, which gets you that minimum 3 criteria, but that does not necessarily demonstrate eligibility for extraordinary ability classification. Now, if it's a relatively short career, it may, if that article was a major seminal paper that reported a breakthrough in your field, that the lesser-known award that you received was particularly prestigious. It was an international award that thousands of people were competing for. But if that is all the evidence that you're going to have, just the very bare minimum, then you should be prepared for likely receiving at least a request for evidence on the final merits determination issue and potentially even a denial. But that's not to say that you can't overcome immigration's prejudice at this stage. It's all about looking at your career as a whole, seeing the arguments that you can make, looking at the evidence that you have to present, and presenting the best possible case for yourself. So some of the final merits determination issues that are going to be specific to scientists and researchers that you're really going to want to emphasize at this stage definitely include the quality of the journals in which you've published your papers, the ranking of the journal, the impact factor, and you're really going to want to distinguish those two things because in the field of engineering, for example, the impact factors aren't necessarily very high, but the number 5 journal, for example, in electrical engineering, which is a category that exceeds, 200-some journals, is going to be something that you can rely on. So don't just look at impact factor, don't just look at ranking. Again, you have to do a totality of the circumstances type of analysis so that the evidence that you're presenting to the immigration examiner is easily understood, and they can also distinguish your field, which, like I said, for some of them, they don't necessarily produce journals with very high impact factors. So part of the challenge in a petition, and this is a great example, is going to be educating your examiner. You want to make it as easy for them as possible to understand, and when you have things like rank and impact factor that you can rely on, you're in really good shape, because even if the immigration examiner doesn't understand what you do, they're not the brightest person, numbers are something that everyone can understand. So when the numbers are on your side, take advantage of it. Along those same lines, the number of articles in the period over which you published is relevant, and that's because part of that EB11 overarching standard that I mentioned is that the acclaim you have enjoyed must be sustained, and the way that immigration interprets that is over a period of time. This is also true for review work. So the higher the number of papers that you've published, or I'm sorry, that you've reviewed, the better. But you also want to emphasize the period over which those peer review services have been provided. The longer you've been doing it, the better off you are going to be for arguing that criterion at the final merit stage. The review work, like I said, it's one of the easiest that you can satisfy as a scientist or researcher, and you can certainly try and review as much as possible, even if you're starting just now leading up to the filing of your case. But again, you may not have that argument on your side at the final merits determination if it's just been a handful of reviews over a short period of time leading right up to filing, because the immigration examiner may justifiably think that you have not been receiving these requests as a result of a claim over a sustained period of time and recognition as an expert, but simply because you decided to volunteer to do peer review services and get a couple reviews under your belt to submit with your petition. I mentioned before about the lesser-known prizes or awards, and that basically student awards and scholarships are generally discounted completely by immigration. And that's because those awards and scholarships are only available to a very limited pool of individuals. So you're not competing against the field as a whole. You're only competing against people at your institution or scholars who are at a very early stage of their careers. Along those same lines, grants have generally not been considered as lesser-known awards by immigration, and that's because they don't view them as awards in the traditional sense where you're being recognized for past achievements, but simply that the merit of your future work is being recognized by the granting body when they decide to fund it. Relating to the criterion of how to establish a critical or lead role, this can be one of the most difficult ones for you to satisfy as an early career scientist because you're not leading your own lab, you're not a PI, but that doesn't necessarily mean that you shouldn't try and present it. So the larger your institution or organization, also the more challenging it can be because it's not just a single project that you have to have a lead or critical role on. You have to have it within the entire organization or establishment that has a distinguished reputation. But if the project on which you occupy the lead or critical role is incredibly important to that institution as a whole or its mission, then you want to try and draw a connection between your role on the project and its function and significance within the organization or establishment as a whole, and how your role on that project, therefore, is actually translates into a lead or critical role for the entire organization or establishment. That's not always the easiest argument to make, but if the facts are sufficiently strong, then try to make it. And the reason that I say that is because even though you only need, technically, the minimum 3 out of 10, it's always better to argue 4, 5, 6, as many criteria as you can that is not a completely specious claim, because if immigration disagrees with you on even just 1 and you've only argued 3, then you have nothing left to fall back on. 4, 5, or 6 criteria gives you a little bit of a safety net. So in regards to the original contributions and also that same critical lead role criteria, many of you, if you've explored this or any of the other options that we're going to talk about in a few minutes, have probably heard about the significance of reference letters to your petition. And that's because it really is one of the best ways to articulate what your contributions have been and why they are of major significance. And that's particularly true if you don't have a very high citation record, because again, I mentioned that numbers is something that it's very easy for immigration to understand. So sometimes they'll just look right at the citation record. If it's sufficiently high, they may not look any further. But if you don't have that kind of a wow factor with your citation record, then the letters become very important to confirm the major significance of those contributions that you've made and that you've reported in your published papers and in your presentations. So who you're going to be asking for the reference letters becomes important, because the higher this person is in the field, the more credibility and weight their letter is going to carry. At the same time, if you're picking someone who is significantly more acclaimed and accomplished than you, immigration sometimes has the tendency to say that you couldn't possibly be of an EB-11 caliber because your referees are obviously so much higher up in the field than you are. I haven't seen that argument in a while, so I don't know if they're still making it, but it's just something to consider. One of the easiest ways, perhaps, to just get around that problem is not submitting the referee's CV. If they have a 48-page CV and you have a 4-page one, definitely don't submit it because that just invites an unpleasant comparison. You can always just do an online printout from the person's profile on their institution's website. So the filing process relating to the EB-11, I mentioned that it is a type of immigrant visa petition. And the immigrant visa petition is not actually the green card application. It forms the foundation for it. So it's your basis on which to immigrate as a permanent resident. And all employment-based immigrant visa petitions, whether it's self-sponsored or employer-sponsored, are filed on Form I-140. So that is the first step in the process. The second step is the actual green card application. If you're within the U.S., you can file what's called an I-45 application for adjustment of status. If you're abroad, you're going to consular process. Now, the really nice thing about the I-45 application is that when you file it, you can also request, as part of the same filing fee, you don't have to pay any extra, an employment authorization document and an advance parole travel document. And the latter is very nice for those of you who have been stuck in long administrative processing or security delays in connection with visas, because the advance parole travel document allows you to travel internationally without having to go through that visa application process. If you have a spouse and or minor children, and that's under the age of 21 and unmarried, who are going to be immigrating with you, they also get to file their own 485s based on your I-140, and they can also request that employment authorization document and advance parole travel document. The EB-11 category nearly always allows for concurrent filing, and that is basically where Step 1 and Step 2 are combined and submitted to immigration at the same time. You don't have to do them together, but obviously the sooner you file the green card application, the sooner you're going to get the green card, because it can only be approved once the I-140 is approved. The EB-11 does have the option of premium processing, and that's just an additional fee to the government of $1,225, and that guarantees you a response from immigration within 15 calendar days. Now, that response is not necessarily going to be an approval, so you're not buying yourself an approval, but it at least guarantees you a response. So whether or not you're able to concurrently file depends on this little chart right here, which is called the Visa Bulletin. I'm only showing the first 3 preference categories in the employment-based section. There's actually 5, but we won't be touching on those. And when you have that letter there, C, which means current, that means you can currently file. If there's a date, that means that option is not available, and that is because that category for that country is backlogged. And what that basically means is that the demand for the visa numbers exceeds the supply, and sometimes the demand is so significant compared to the available visa numbers that the cutoff date is really, really far in the past. And if you're not familiar with the Visa Bulletin, it can be extremely confusing. I won't spend a lot of time on it, but if you have follow-up questions, my contact information is going to be at the end, and you can certainly reach out to me. But what those cutoff dates basically signify is when you're able to file your green card, because the I-140 can be filed at any time. There's no restriction on that. The I-485 is what cannot be filed until what's called your priority date is current. So the priority date is established for purposes of this conversation when you file your I-140 petition. And if you are in a backlogged category or country, after you file your I-140 and it's approved and you have your priority date assigned, you're basically just sitting here watching the Visa Bulletin on a monthly basis, waiting until you have a current date. So basically, if you are born anywhere, EB-11 is a great category for you because, as you can see, it's current across the board. If you were born in India or People's Republic of China, it's especially advantageous to fit into the EB-11 category, or just EB-1 in general, because as you can see, there's quite a backlog for EB-2. And it's particularly awful for India right now because that November 15th, 2004 date has not moved, and it's even moved backwards in some cases pretty recently. So the most important thing to remember about the Visa Bulletin is that it doesn't always move forward. It doesn't move forward at a predictable pace or rate, and it can sometimes even move backwards. So looking at this, you would think, okay, if I'm from India and I have an EB-2, I'm necessarily going to have my green card in about 10 years. That's not the case because, like I said, the dates don't move forward on a month-by-month basis, even though the Visa Bulletin is released once a month. So that was Visa Bulletin 101. I'm sure it didn't make sense to very many people. So like I said, if you have any questions, feel free to reach out to me after the webinar. But for purposes of this discussion, the important takeaway point was that if you were born in India or People's Republic of China, you want to be EB-1. Now, with that being said, we're still going to talk about EB-2 because for everyone else, it is probably going to be the best option. And the reason for that is because the EB-2 National Interest Waiver is such a lower standard compared to the EB-11. Just like the EB-11, it is a self-petition. There's no employment offer required. And it has a very straightforward three-pronged test. There's no criteria. You get to pick and choose your evidence. It doesn't have to fit into a particular formula that's outlined by the regulations. It's very flexible. That being said, you do have to satisfy all three of these prongs. So you have to demonstrate that your work has substantial intrinsic merit, that the benefit of that work is national in scope, the benefit to the national interest, and that the national interest would be adversely affected if the labor certification requirement were not waived. Now that last one seems kind of confusing, but when it gets right down to it, it's relatively straightforward, and I'll touch on that in a second. Now, what it has to do with that labor certification requirement, that's what you're actually asking to be waived when you apply for an NIW, because instead of going through the process where you have an employer who tests the labor market to see if there's any qualified, willing, able, and available U.S. workers for your position, you are absolved of that. You don't have to demonstrate that there's no U.S. workers to do the work that you're doing. You don't even have to have an employer sponsor you. You're basically saying that your contribution to the field thus far has been so significant that you should not be held to that standard. And that's really what the third prong is saying. It requires a demonstration that you have had some impact, some degree of influence on your field as a whole. And even though the crux of the national interest waiver is prospective benefits to the national interest by virtue of your work in the U.S., they really are going to focus on that prior record of achievement. So even though the work has to be, of substantial intrinsic merit, the benefits of the work have to be national in scope, just focusing on your work and how important it is and how beneficial it is not going to satisfy that three-pronged standard. You have to establish that you as an individual have had some degree of influence on the field. So that's obviously, like I said, a much lower standard than the EB-11 because you don't have to prove that you're at the top of your field. You don't have to prove national or international acclaim. You just have to provide evidence of some degree of influence. So that being said, you still do have to establish that you've distinguished yourself to some extent and had an impact. It's not sufficient, like I said, to just argue that the work that you're performing is so beneficial or important that anyone who's doing it should be granted an NIW. So some of the issues in the NIW analysis that immigration is going to focus on most heavily really relates to publications, because again, especially if you're in academia, they know that the rule is publish or perish. They think that that is expected of anyone who is in academia, and if you don't have a publication or citation record, that's something that they're going to look at as a potentially negative factor. Now, that's not to say that there isn't other evidence that you can argue in order to meet your burden of proof, but you may need to address why the citation or publication record is not exactly where the immigration examiner expects it to be. So when looking at your publications, first author is beneficial, especially when it's on a paper that has a higher citation record. And that's because the collaboration, again, the work that was produced, is not necessarily going to be the sole focus of the inquiry. It's what your contribution was to the work that had some degree of impact on the field. So the lower you are in the list of authors may mean that the contribution of the work reported in a given paper is not attributable to you. Immigration may interpret that as you having a very small role. So first author, where you are in the list of authors, is something that may become an important factor depending on the other facts of the case. Now, I said that a limited publication record is something that may be cause for concern, but that can certainly be overcome if you have a very high citation record. So there's a bit of a ratio analysis that's going on here with these two records. The lower your publication record is, the higher you're going to want your citation record to be, to reflect that even though you have just a few papers that are reporting your work, the work reported in those papers has been particularly influential. And on the flip side of that, if you have a lot of papers and very few citations, you're going to need to rely on some other evidence to demonstrate how the work reported in those papers has influenced the field, because the citation record is not going to be something you're able to hang your hat on. So along those same lines, in terms of when the contribution and influence on the field can be attributed to you, if you're working in very large collaborations, the significance of the work that is produced by those collaborations may not be something that the immigration examiner is willing to credit to you. And that's where, in the NIW context, the reference letters become very important, because usually you want to focus on letters from independent referees, people who don't know you but are aware of your work simply by virtue of its impact on the field. But if you have a bunch of co-authors on your papers, then letters from those collaborators who describe what your specific contribution has been to the work and why it's so important can become a really valuable piece of evidence. In regards to the processing for the NIW, it's the same as EB-11, but like I said, there's that backlog in the EB-2 category for those born in PRC in India, which means no concurrent filing. There's also no premium processing for NIWs. Right now, the processing time is just about 4 months. So it's not a really significant backlog in terms of processing times, but if you are in a really big rush, then the NIW may not be the option for you, because even though you can only expedite the I-140 and you can't expedite the green card application, because the green card application can only be only be approved subsequent to the I-140. Sometimes you may actually get the green card more quickly if you pursue an I-140 option that has premium processing. So because the EB-2 is a much lower standard for early career scientists who are born in PRC in India, and they're not quite up to that EB-11 caliber, they may want to file an NIW just to get that priority date, that place in the green card waiting line, while their credentials are being built up and later go for an EB-11 one case. And that's particularly important if you are currently or will be going on to H-1B, because there is a 6-year limit on the H-1B. And as you saw, there's at least of right now, a 10-year waiting line for EB-2 India. So what happens if you only get 6 years of H-1B and it takes 10 years to get the green card? What are you going to do for those next 4 years? Sit abroad? No, no one wants you to do that, especially your employers in the U.S. So what you can do is file an immigrant visa petition like an NIW, establish your place in the green card waiting line, and provided that you've done that before your 6th year of H-1B status has begun, you're able to extend your H-1B beyond that 6th year. It's depressing, but some of my clients have been on H-1B for 10, 15 years waiting for their priority date to become current. So that is not ideal, of course, by any means, but it sure beats leaving the U.S. The last option that we're going to talk about is the only only employer-sponsored option that we're going to be discussing. It's also an EB-1 category. It's the EB-1-2, so that's employment-based first preference second category, and it is reserved for outstanding researchers or professors. Like I mentioned, it's employer-sponsored, so no self-sponsorship here, and your employer has to be either a university or comparable institution of higher education, or it can be a private industry employer, provided that they have at least 3 full-time researchers on staff and has documented achievements in the academic field. So, a startup for which you're the only researcher is not going to satisfy that standard. It has to be a private institution that already has a record of achievements in the field. Before you can file, you have to meet a 3-year experience requirement, and that can be for either teaching or research. And the research experience, if you're using what you did for your master's or your PhD, you can only use that toward the 3 years if it's recognized as outstanding. And for teaching, you have to have had full responsibility for the class in order for it to be credited toward that 3-year requirement. The position that you're being offered by the university or private employer has to be permanent, tenured, or tenure track. And the overarching standard, you can see at that last prong there, is recognized internationally as outstanding. So unlike the EB-1-1, national acclaim is not going to be sufficient. This has to be someone who's recognized on an international level for their contributions to the academic field. That being said, international really just means more than one country. So if you have a record of achievement for your graduate studies in your home country or another country and then recognized here in the United States, technically you meet that standard of being recognized internationally for your achievements. Like the EB-1-1, we are given a criteria checklist. Instead of 3 out of 10, you only have to meet 2 out of 6. And I won't read them because you can see them there up on the screen. I'll just point out some differences that are worth noting from the EB-1-1. The first that I want to point out is the third prong, the third criterion, published material. I mentioned how with the EB-1-1, they love to deny satisfaction of that criterion because your name isn't mentioned. For the EB-1-2 standard, it just has to be about your work in the field. Your name doesn't have to appear anywhere because it's not published material about you. That being said, if you're mentioned by name, that certainly gets you a bit further, but it's not actually a requirement in order to satisfy this criterion. Membership, pretty similar. Prizes or awards, pretty similar to EB-1-1 as well. Participation of the judge of work of others, again, that's review work. And then original contributions, you don't see that phrase major significance there. So that is a bit easier to satisfy than the similar criterion for EB11. The only thing different about the authorship of scholarly books or articles is that they can only be published in journals with international circulation in the academic field in order to be considered as satisfying this criterion. So those are the 6 criteria that you can meet. The thing that's nice about these is that unlike the EB11, which applies to the sciences, the arts, the athletics, business, these criteria are obviously specifically tailored to academics, professors, and researchers. So technically, it should be easier to qualify under EB12, provided that you have that recognition on an international level. Now, something that I don't think I mentioned, but is certainly worth mentioning here, the second step, the final merits determination, also applies in the EB12 context. It does not apply to NIWs, and that's another reason that that category is so preferable compared to the EB11 and even the EB12 in some cases. You don't have to worry about immigration saying, yeah, I think that you meet the 3 prongs of the NIW standard, but I'm still not really sure that you're eligible. They don't get to do that in the NIW. There is no final merits determination. In the case of EB12, just like EB11, the immigration examiner could come back and say, yes, you've provided evidence demonstrating satisfaction of at least 2 of the 6 criteria. However, when I'm looking at your case, I just don't get the impression that you are really recognized internationally as outstanding. So when you're putting your EB12 petition package together, just like with the EB11, you really have to be cognizant of the quality of the evidence that you're putting in. It's not just about quantity. It's not just about meeting that minimum level. It's about putting together a package that truly demonstrates that you meet that overarching regulatory standard for this classification. So I mentioned immigration coming back in particular on the final merits determination issue, and the way that they communicate the final merits determination, or if they don't think you've met the minimum number of criteria, is in a request for evidence. And that is a written communication from the immigration examiner. And if you get one, you don't necessarily panic. They're not uncommon, especially for EB11s, because it is such a high and subjective standard. That being said, the first thing that you should do when you get the RFE, not panic, but read it carefully. And that is because these immigration examiners are not sitting down and typing you out a little love note. They are copying and pasting from an existing template, and they can sometimes be a bit sloppy. They may be rushing to get your RFE out on the 15th day if you filed under premium processing, and they don't always do a great job. So sometimes they will be asking for documentation or evidence that is not required in your case. It's not required in order to meet the burden of proof for the immigration benefit that you're applying for. So make sure that the officer, if they are asking for something that they are not entitled to ask for, that you're not required to provide, you want to note that in your response, because if you fail to submit all of the evidence requested, that can be grounds for denial. So if you're not submitting something that was requested, you want to be able to explain very clearly why you're not doing it, and that's because it's not actually required. So immigration can't demand that you submit evidence that's not required by the legal standard, so don't let them get away with that. Along those same lines, you want to read the RFE carefully, because sometimes you need to read between the lines. It's not always necessarily going to be easy to determine what the officer's particular concern is with your case. So before you start preparing your response, you want to read the RFE through once or twice. Make sure that you really understand why the officer is not convinced that you qualify and what additional documentation and information you can submit in order to satisfy your burden of proof. One one complaint that we have seen quite frequently in I think really all three types of petitions, NIW, EB-12, and EB-11, is that the reference letters that are submitted in support of the petition are the quote-unquote cornerstone. You're trying to rely primarily or exclusively on those letters, and immigration basically looks at that as a very strong negative factor because they think that everyone in academia is just willing to sign a letter regarding what it says. They're just doing their friends favors and you're doing it for them and vice versa. They don't understand the level of integrity that is involved. And so they view these letters with suspicion. They know that they're solicited forms of evidence that they do not weigh as heavily as pre-existing evidence. So in submitting the letters, you can't rely on them exclusively to demonstrate that you meet whatever criteria you're trying to use them for, usually original contribution or influence on the field. You have to demonstrate how the statements in those letters are corroborated by the quote-unquote independent evidence. And what immigration considers more independent and objective is your publication record, invitations to present, invitations to review manuscripts, so on and so forth. So if you decide to pursue one of these immigration benefits and you're putting your package together and you notice as you're getting closer and closer to submission that the bulk of it is reference letters, that's probably not going to be an approvable petition. Okay, we have reached the end of the webinar, and you can see my contact information up there on the screen. My email address is jmarks@wolfsdorf.com, so feel free to reach out to me with any questions and, excuse me. Excuse me. I will take some time now for questions that have been sent to me through the chat box. So if you've been saving them till the end, go ahead and send them. If you send a question that's specific to your case, I will respond via email instead. So feel free to send it to me at that address up on your screen, jmarks@wolfsdorf.com. So the first question I have pertains towards scholarships and fellowships from the European Union. Can they be considered as satisfying the criteria related to awards and prizes for the EB-11 or EB-12 classifications? And my answer to that, really with a question pertaining to any scholarship or fellowship, is it depends. I think it's unlikely, but what you really need to look at is what are the criteria for the scholarships and fellowships that you've received. Who is eligible to be given these scholarships and fellowships? If it's only scientists who are at early stages of their career, if it's only for individuals from a certain institution, then that's going to be problematic. Similarly, if it's just funding, for you to do a postdoc or a particular project, that's probably not going to be recognized as the recognition for achievements, which is really the standard for all of the different immigrant visa petitions that we discussed. It's not just about getting a competitive grant for research that you're doing, because that is, again, in immigration's eyes, just recognition of the merit of the work that you're going to be performing as opposed to your past record of achievement. So you would need to look at the criteria for the award, who was competing for them, who's received the award in the past can sometimes be compelling evidence. If it's people who have risen to the very top of the field for the EB-11, that's certainly good evidence to point to. But in general, immigration is going to be very stringent and very rigid about considering a scholarship or fellowship, especially granted only to early career scientists, as meeting the EB-11 or EB-12 criteria related to awards. So I think that one of these questions I've touched upon a bit, and that is it better to demonstrate that you satisfy more than just 3 criteria? Absolutely, because if immigration disagrees with you on 1 or 2 of them, you want to have some additional criteria to fall back on. I don't quite understand what the rest of this question is saying. Satisfy only 3 of them, but with strong evidence of sustained a claim within each one. I think that what the question is trying to ask is, does it matter the quality of the evidence that you submit in order to satisfy each criterion? And the answer is definitely yes. In terms of all of these visa petitions, like I said, it's very much quality and not quantity. So that doesn't mean that every single criteria that you're going to argue is one that you must necessarily overwhelmingly satisfy. Some of them you may just be submitting evidence to give yourself that 4th or 5th or 6th or even 7th criteria, just to give your application some padding, a bit of a safety net. But certainly any of the criteria that you satisfy, you want to present the strongest possible evidence for each one of them so that you not only get past the first stage, but also the second page of the final merits determination. So one of the questions is relating to what status you're on when you apply. And this is a really important question because if you are on a strict non-immigrant intent visa like a J1 or an F1, there is some risk in filing an immigrant visa petition and also an application for adjustment of status. Just filing the I-140 in and of itself is problematic. Filing with the application for adjustment of status can also have some additional risks. I don't know if I have time to go into all of them, but basically the rule of thumb is that immigration views filing an immigrant visa petition as some manifestation of immigrant intent. So with the F1 and the J1, if you file an I-140, traveling can become extremely difficult, and there's a risk that you may not be able to come back. And that's because if immigration looks into the system and sees that you have a pending or approved immigrant visa petition, they may not think that you're any longer a legitimate F1 or J1 because you've expressed that immigrant intent. So you would almost certainly be denied a visa if you had to apply for the visa at a consulate or embassy abroad, and you may have difficulty at the border when you're coming back in. So even if you don't have to apply for a visa in order to take a trip abroad in order to come back, there's still the issue of the Customs and Border Protection official at the border looking into the system, seeing that you may have expressed some immigrant intent, and then questioning whether they should let you back in. So along those same lines, the question of timing, if I'm on OPT, should I apply for the I-140 now, or should I wait until I get on an H-1B? Should I use all of my OPT time? Should I file concurrently? Should I just file the I-140? These are all very fact-specific questions that we would need to explore in the context of your individual case. But as a general rule, it is going to be a bit safer, I would say, to wait and apply if you're on an H-1B. And that's because unlike the unlike the J-1 and the F-1, the H-1B is a dual intent visa, meaning that you can have the intent to immigrate permanently and apply for a green card and at the same time still hold your H-1B. That's not the case with the J-1 or the F-1. So if you file an immigrant visa petition and you're on an H-1B, you can still travel, you can still apply for a visa. If the immigrant visa petition is denied, then you're not necessarily going to have a problem of, still pursuing other opportunities, whereas if you're on the J1 or the F1, having that denied immigrant visa petition, depending on how much time you have left on your DS 2019 or your I-20 or your OPT, may put you in a bit more of a precarious situation. That being said, I've done dozens of immigrant visa petition self-sponsor cases with postdocs and even PhD candidates who are on F1, OPT, or J1s, and it's all turned out fine. It's just all about how much risk you want to assume, and of course we could discuss that and figure out what the best strategy is going to be for you. So I think that's all the time that we have today. If I didn't get to your question, please feel free to email me. Again, my contact information is up there on the screen. Just mention that you listened to the webinar. And again, I thank you for attending, and we very much hope to hear from you and to be of assistance to you. Thanks again.